Good morning and welcome to Goth Square Live. My name is Stuart, Jessop, and today I'm joined by Sabrina, Goodchild. We are both barristers specialising in consumer law, and we welcome you to this episode of Goth Square Live on the subject of product recalls. Consumers are entitled to know that the products they purchase are safe. Regulators must ensure that businesses do not manufacture, distribute, or place on the market any products that are dangerous, and businesses have the legal obligation to ensure that their products are compliant and safe. However, there are some occasions where products do not meet safety requirements and need to be withdrawn or recalled. Getting such corrective action right impacts not only on the consumer and its safety, but also the reputation of the business concerned. This episode of Goth Square Live provides an overview of how a business should plan for, implement and manage a product recall, and what the law and the regulator will expect. This presentation will not cover recalls governed by product-specific regulations, but will instead focus on the General Product Safety Regulations 2005 in respect of consumer products only. The first half of the presentation will be delivered by me, and Sabrina will deal with the product recalls once a safety incident has occurred and discuss potential reforms. A producer must not place products on the market unless they are safe. Regulation 5 of the GPSR deals with that. And a distributor must not supply a product which he knows or is presumed to have known is dangerous. A producer and distributor must also monitor the safety of their products after they have been placed on the market. If a safety issue arises with a product, the GPSR requires that the producer must be prepared to take appropriate action, which is governed by Regulation 7, subsection 3b. This will often include notifying the relevant authority. The GPSR does not provide legal guidance on what corrective action is appropriate in any given situation. However, traceability, early detection and warning systems, customer databases and retailer sales records may assist in determining what type of action to take, as well as providing vital information in any withdrawal and recall from the market. Section 7 of the GPSR provides, under subsection 3, within the limits of his activities, a producer shall adopt measures commensurate with the characteristics of the products which he supplies to enable him to A. be informed of the risks which the products might pose, and B. take appropriate action, including where necessary to avoid such risks, withdrawal, adequately and effectively warning consumers as to the risks, or, as a last resort, recall. The GPSR does not define appropriate action, but it does include, where necessary, withdrawal, warning consumers as to the risks, and as a last resort, recall. To determine whether a product recall is the most appropriate corrective action, a full risk assessment of the safety issues should be completed first. Of particular importance to business and regulators in taking the most appropriate corrective action is the Code of Practice on Product Recall and Other Corrective Actions, PAS 7100 of 2022, issued by the British Standards Institution. The guidance aims to help businesses understand what they need to do if something goes wrong with their product and plan for that eventuality. The code is intended to be read in conjunction with PAS 7050, again of 2022, another code of practice which supports businesses and regulators in complying with their relevant legal duties relating to placing safe products on the market. The code suggests the following as corrective actions: withdrawal of products from sale and distribution, product recall, offering consumers the choice to replace, exchange or repair the product, modifying products in the consumer's homes, improving the instructions supplied with the product, communication to alert consumers on the proper use of the product, modifying products in the distribution chain, introducing additional quality control measures, changing the design of the products, changing the production method. Determining that a product recall is the most appropriate corrective action will usually be a last resort for most producers. A risk assessment should be carried out before such a decision to recall has been finalised. Once a decision to recall has been made, it must be carried out quickly and efficiently as possible so as to achieve its objective and limit any harm to others or to the product and brand itself. Considerable care needs to be taken when designing and testing and then monitoring a recall system. The aim is to limit the scope and cost of the recall by containing the problem, and that objective should be communicated and reviewed throughout the process. The Code of Practice is a useful tool in planning and carrying out the recall. A product recall can be broken down into the following stages: notifying any relevant regulators, design and launch the recall, monitoring and reviewing the product recall, and post-recall actions. The code takes the form of guidance and recommendations only, and it is not legally binding, and compliance with it does not provide immunity from legal obligations. The code provides practical guidance for businesses and does not replace or override any of the legal duties to which businesses or regulators are subject. Part 1 is intended to help businesses prepare to manage a possible safety-related product recall or other corrective action, establish mechanisms to monitor the safety of consumer products, investigate any potential product safety issue, establish mechanisms to deal with any product safety issue identified, establish and implement a communication plan in respect of a product safety issue, review corrective action programs to ensure that product safety responsibilities continue to be met. And Part 2 is intended for regulators and enforcement authorities and sets out the guidance and advice that should be made available to enable businesses to meet their legal obligations and act in the public interest. Advance planning for corrective actions is very important. The code places significant emphasis on the need for businesses to create and develop a product safety incident plan, PSIP, to enable them to respond quickly when product safety issues arise. The code states that all producers, importers and distributors operating in the UK should each have a PSIP in place. A PSIP should include policies and plans required by a business to deliver an effective recall or other corrective action. The code emphasises the need for senior management commitment to the development and operation of the PSIP. The business should ensure clarity around exactly who is responsible and accountable for both the development and the operation of the plan, and that sufficient resources are assigned to it. A PSIP should include the following elements where appropriate and provides greater detail on each: a product and customer traceability plan, a product safety monitoring plan, a legal notification plan, a risk assessment plan, a corrective action plan, a communication plan, a training plan, a testing plan, a review plan. The code places significant emphasis on communication. In particular, the code identifies communicating with the following as key to effective management of product safety issue: relevant regulators, internal staff members, business customers, distributors and suppliers, online marketplaces, consumers, the media. Producers with a comprehensive and up-to-date PSIP in place can act speedily and appropriately to any product safety issue. The code recommends that the PSIP should include template corrective action and announcements, and specifies that announcements should be clear, concise, factual, and easily understandable by all. This part of the process is vital. Effective communication of the corrective action can minimise harm both to consumers and to the business itself. A corrective action announcement should always contain the following: a clear heading that draws attention to the announcement containing the words "important safety warning" and a description of the corrective action such as product recall, a clear description of the hazards such as fire, electrocution, asphyxiation, and associated or potential safety risk, product identification, details such as brand, barcode, colour, size, a photograph of the product, details of when and where the product was available for sale, a description of the action required by any consumer who believes they had the product covered by the announcement, details of arrangements for any proposed refund, exchange or repair, a website address, and a free phone number for further information. Where possible, the code also recommends that the following additional product information should be included: model batch number, serial number, and where they are to be found on the product. Additional information to ensure consumer safety, such as stop using immediately unplug and do not use pending repair, do not touch or move, etc. A separate annex to the code provides further guidance as to the content and layout of the corrective action communications. Regulators must support businesses in the preparation of the PSIP by providing assistance and advice. Once an incident has occurred, there are various obligations on the business, and Sabrina will now speak to you about this.
Thanks, Stuart. So we've got an overview of the legislative regime and what's expected of businesses in preparation for the possibility of a product recall. But what should happen when information becomes available that indicates that a product safety issue has arisen? The short and very high-level answer: follow your product safety incident plan. But of course, some businesses may not have one, and even if they do, it will likely have been drafted in a very general way when, of course, specific considerations arise depending on the product to be withdrawn and the specific issue with the product. Even if you have a PSIP, that can really only be viewed as the starting point. Now, the code of practice mentioned by Stuart helpfully visualises a typical corrective action sequence, which should now appear on your screens. This identifies the key steps, again as summarised by Stuart, of a product recall. Now, there's not enough time to go through all of the necessary steps comprehensively, but we are going to look in a little more detail at risk assessments, notification, consumer identification, and how to conclude a product recall. We will then consider what might happen if you fail to recall a product which really should have been recalled, and future reform. Starting with risk assessments. As you will have seen from the typical corrective action sequence, risk assessments feature from the very outset. The risk assessment process is intended to begin at the same stage as information being received about the potential product safety issue, be used in the initial inquiries and further investigation, and be completed before the decision on corrective action is taken. The reason for this is that the risk assessment is used to determine first whether there is a genuine safety issue that exists, or whether the problem is isolated and doesn't present a hazard to a larger group of consumers, and second, to determine the appropriate corrective action. In summary, it involves making an objective analysis of the degree of potential harm and the likelihood of its occurrence. Now, there are several methodologies that can be used to conduct a risk assessment. Historically, you had the EU SafetyGate, RAPEX risk assessment methodology, which was used, but this has been updated by PRISM, the Product Safety Risk Assessment methodology. And you've also got the nonogram methodology. Lots of information is required to complete the risk assessment, including the number of products in circulation, information on customer complaints, and potentially scientific input on the cause and consequence of hazards, and potentially on foreseeable use and the path to injury. So, for example, the skills of an ergonomics expert or a paediatrician. The headline point: underestimate the risk assessment process at your peril. It is a starting point which may at a later date be carefully pored over for businesses and also enforcers alike. Next, we're looking at notification. So Regulation 9 of the GPSR requires that where a producer or distributor knows that they have placed on the market or supplied an unsafe product, they are required to notify the enforcement authority, usually their local trading standards department, forthwith. It's quite an important requirement and one that you really don't want to get wrong, as failure to notify is a criminal offence where it's proved that the producer or distributor ought to have known that the product posed a risk to consumers incompatible with the general safety requirement. The Office for Product Safety and Standards, OPS, has produced some guidance on notifications, the most useful part of which is the suggested notification template. The template includes business contact information, product identification, including batch numbers and photographs, detail of the risk assessment, corrective actions already taken or planned to be taken, and the economic operators in the supply chain with affected products. But of course, the initial notification is unlikely to be the end of an enforcement authority's involvement. They will need to be informed of a decision to recall and will expect to be provided with a copy of the recall plan. And in certain circumstances, the authority will give onward notification to OPS through its UK-wide product safety database, effectively where the consumer product presents a serious risk in need of urgent investigation or presents a non-serious risk requiring regulatory intervention. So next, we're on to consumer identification. A significant stumbling block when conducting product recalls is often the difficulty of identifying and communicating with customers. This most commonly arises when there's no customer registration of a product, whether by customer failure or the type of product that you're dealing with. You could have the best recall system in the country, but without the customers to notify, have a wholly ineffective recall. So where there are problems with customer identification, often imaginative thinking is needed to identify how customers can be identified. Some areas include looking at servicing records, distributor loyalty schemes, product delivery information, records kept by distributors, even liaising with banks and credit card providers. And of course, the key, as with all steps of product recalls, is the record of the steps taken, including how consumers have been identified and what steps have been taken to notify them, and then to review the effectiveness of the steps taken thereafter. You can expect a comparison to be undertaken between the number of affected customers and the number of successfully contacted customers. Obviously, the higher the percentage of customers successfully contacted, the more likely the recall is to be a success. And if the percentage is too low, you may need to go back to the drawing board to see what additional steps can be taken to contact consumers. Maybe a national marketing campaign now needs to be considered. As for the conclusion of product recalls, there isn't a hard and fast rule about when a corrective action programme is deemed to have been successfully completed. And the length of time before a corrective action is closed depends on numerous factors, including the product, the hazard, the method of sale and the price, etc. However, the code helpfully provides a checklist on concluding corrective action, including product recalls, which should again appear on your screens now. For me, the top 3 tips are firstly, to continue to have information available, most likely on the business's website, on the recall and corrective action, just in case customers not initially identified subsequently identify the safety issue. Second, to continue to collect data on the progress of the recall and keep the regulator updated. And then finally, is there any learning that can be used to improve the PSIP going forward? So what happens if there's a failure to recall or insufficient corrective action process? Well, the local authority or OPS is likely to get involved, and a variety of enforcement measures are available under the GPSR. And now, whilst dialogue and voluntary action are often preferred by local authorities, the local authority's powers extend to suspension notices, preventing a product being placed on the market or supplied whilst an enforcement authority organises its own safety evaluation of the product. They also include requirements to mark or warn, withdrawal notices if the product poses a serious risk requiring urgent action, or the remedial action being taken is unsatisfactory or insufficient, and then finally recall notices. Those are obviously different to voluntary recalls, and these notices require the producer or distributor to recall a product at the local authority's direction. So what next for product recalls? The Product Safety Review was launched in August last year. It looked at various aspects of product safety, including product recall. The most notable proposal for recalls was the government proposal to introduce a requirement for all product-related incidents of a certain unspecified level of seriousness to be raised by businesses to OPSS directly, rather than local authorities subsequently notifying. The purpose of the proposal was to ensure a centralised response and aims at increasing consumer protection. Now, the consultation closed in October last year, but somewhat surprisingly, the government response is still outstanding. And that's despite the 18-month implementation period for the EU General Product Safety Regulation, which contains sweeping reforms and will start a significant divergence between the UK and the EU, ending in December 2024. So whilst product recall forms a very small part of the consultation, we are still eagerly awaiting the government's response and any effect that it will have on recalls going forward. Now that's everything for today. We hope it's been useful, and if there are any questions, please do get in touch. The next Goss Square Live will be on the 5th of November, fireworks night, so do keep an eye out for that. Thank you and good morning.